I rise in support of SCA 10 to our California State Constitution. We need this amendment, members, in my judgment, because the actions taken by the Supreme Court, as was indicated by the pro tem, are on the verge of dismantling a woman's right to choose. And I think it's important to point out the very glaring fallacy being put forth by those seeking to strip a woman's right to choose. The argument they make is that the United States Constitution contains no right of privacy. They say correctly I might add, that the words abortion itself never appears. And the suggestion is that because these specific words don't appear in our Constitution, the precedents regarding a woman's rights to choose can easily be cast aside and overturned. But here, ladies and gentlemen, is what they're not telling you. The right to privacy has been embedded in our constitutional precedent for nearly a century. It protects every one of us in ways so fundamental we now take them for granted. And to surrender it would be the gravest mistakes. For example, as a parent, do you think you have the right to allow your child to learn a foreign language? Well, back in 1923, Nebraska didn't think so. The state, amid a wave of anti-immigrant xenophobia, made it against the law to teach German to your children before the 9th grade. What stopped them? The United States Supreme Court, citing the right of parents and teachers to decide such things for themselves. Who's Mike? Let's talk about birth control. Should the sheriff be allowed to search your bedroom for contraceptives? Anyone here today ready to let the government decide? The answer is no. You can thank the Supreme Court for your right to privacy. Anyone here today ready to let the government decide what books and magazines you can read? Until 1965, ladies and gentlemen, it was a law of the land. That's when the Supreme Court of the United States unanimously found a right of privacy fundamental to the concept of liberty contained in our Constitution. The case had nothing to do with abortion. It was about a couple's dirty movies found at the home of a suspected bookmaker. But the fundamental principle, ladies and gentlemen, the fundamental principle of keeping government out of the people's private lives is the very same one that protects a woman's right to choose. Here's how Justice Thurgood Marshall put it. If the First Amendment, ladies and gentlemen, means anything, it means that a state has no business telling a man sitting alone in his house what books he may read or what films he may watch. Our whole constitutional heritage rebels at the thought of giving the government the power to control men's minds. If the court was correct in keeping the government from trying to control the minds of men, surely the same protection must apply to the bodies of women. Today, these antiquated laws, struck down decades ago, sound ridiculous, medieval, even Orwellian. But they weren't thrown out simply by chance or by the march of progress. In every instance, they were set aside by the High Court's recognition that the true human liberty only exists when people are allowed to make their own decisions about their minds and about their bodies. I would argue, Madam Pro Tem and members, that a woman's right to choose is as fundamental as basic to our liberty as the right to read and study and live the life you want. They all rest on the same foundation. To destroy one is to threaten them all. We stand here today because those rights are in peril, and we must do all we can to protect them. I ask you to support SCA 10. Thank you very much.